All India Open Mock Test from 23rd of September to the 2nd of October. Go ahead and register now in the BYJU'S Exam Prep app and compete against thousands of aspirants. A very, very warm and a hearty welcome to each and every one of you friends. As you know, BYJU'S Exam Prep brings to you a fantastic session on this particular class wherein we are going to discuss with you about certain very, very important and landmark judgments that have come up very recently. So if you are preparing for CLAT 2023, it is absolutely necessary for each and every one of you to go through these important judgments. So we bring to you part 3 of the top 20 legal judgments for the year 2023. This is part 3. So friends, in these sessions, we try to tell you certain very important legal developments which has come by way of important judgments from the courts in India, preferably the Supreme Court of India. Now, as you know, the Supreme Court of India, the judgments that they pronounce is binding on each and every authority. So, the bindingness of a Supreme Court judgment is paramount, and henceforth, we today are going to look at some of the most important legal judgments that have come from the Supreme Court in this part 3 of top 20 legal judgments. So without much ado, let's begin. A very good evening. Okay, a very good evening to all of you. I can see each and every one of your chat. Fantastic. Great to see you guys. So guys, let's begin. The top 20 legal judgments part 3. Now, these are the list of cases that we are going to discuss in the course of this session. Devarakonda Money versus Care Hospital. This deals with medical negligence. Just because a patient has died, inside a hospital doesn't mean that the doctor is negligent. Okay, so the patient has to prove that there was some amount of negligence on the part of the hospital to claim those compensation. Then we are going to talk about Rashidul Jafar, then State of Jharkhand versus Salauddin Khan, G.N.R. Babu versus Muthappa, and Rajiv Shukla versus Gold Rush Sales and Services. So these are the 5 important judgments that we are going to talk about in the course of this session. So definitely before we start, I would request others also to join this session, because this will be a very, very important session wherein we shall be concentrating to understand. We shall try to understand certain very, very, very important judgments. I'm going to explain to you what the Supreme Court has said and the repercussions of these kind of judgment. Okay, so guys, let's begin. Okay, let's see. Okay, as of now, there are around 20 students, 17 watching now. I want more and more of you to share this session, so that unless and until these around 40 students see this session live, it is no point. Okay, I want more and more of you to share this session as soon as possible. Do like the session, and definitely I'm there on the chat box. I can see, okay, Aditi Agarwal, Priya, very, very good evening to all of you. Very, very good evening to all of you. I want more and more students to join this session, because this session will be very, very crucial and important for each and every one of you. So guys, let's get started. Let's get started with the first important judgment, and that is Devarakonda Money versus Care Hospital. Now, in this particular case, the Supreme Court held that just because a death has happened inside a hospital, it will not necessarily be amounting to medical negligence. Now, unless and until a patient or the family of the patient who has died is able to establish that there has been some amount of negligence, or there was a lack of care by the authorities in the hospital, it will not be considered as a case of medical negligence. So the Supreme Court in this judgment said that every death in a hospital does not amount to medical negligence. So just because a death has happened inside an institutional environment, of an hospital, does not necessarily amount to medical negligence. Now, unless and until the patient or the family of the patient is able to prove or to show to the court that there was lack of medical care, unless and until it is shown that there was lack of medical care, it cannot be construed as a case of medical negligence. Okay, a very, very important things that have been stated in this particular judgment. Okay, am I clear, each and every one of you? Okay, is that clear to each and every one of you? Okay, now apart from this, the Supreme Court said that unless the patient or the patient's family is able to establish, now this is very, very important. Now this becomes very, very important for each and every one of you. So the Supreme Court in this particular judgment says that unless and until the patient or the appellants who came to the court is able to establish before this court any specific course of conduct suggesting lack of due medical attention. Just because a person has died in a hospital will not always mean that there was medical negligence. It could be something else. It could be, the patient was old and stuff like that. Now, I'll give you an example. Now, the Queen Elizabeth II, who passed away about 7 days back. Now, she was 96. She died happily. That is what the monarch has said. Now, please try to understand, was there lack of due medical attention to the Queen? No. But there were hundreds of doctors taking care of her in her Balmoral Castle. Now, just because she died, it cannot be concluded that the doctors were at fault. Right? Please try to understand that. So, in the absence of any material disclosing medical negligence, it is not to be considered as doctor's fault. Is that clear? Am I clear to each and every one of you? Did you all understand this? Just because inside a hospital a particular patient has died doesn't mean that there was medical negligence on the part of the authorities, that is the doctors and the hospital authorities. Am I clear to each and every one of you? Any doubts? Any doubts, please let me know. Okay? Any doubts, please let me know. Okay? Okay. Now, I'll just wait so that everyone has understood. Any doubts, you are most welcome to ask me. Okay? Any doubts? Any doubts? Ashwini Yadav, Shubham Raj, Priyanka, Pandey, Anil. Okay, any doubts? Okay, Asmita saying any doubts that you have a right to ask me those doubts. Okay, so in this particular case, the Supreme Court said that just because a person died inside a hospital does not always mean that there is medical negligence. Okay, am I clear, everyone? Every one of you? Okay. Brilliant. So moving on to the next important judgment. The next important judgment is Rashidul Jafar versus State of Uttar Pradesh. Now, what was this judgment all about? Now, the Supreme Court has very categorically stated that every state has a right to come up with certain policy for premature release of a person who is incarcerated. So a person who has been held to be guilty of a crime and is inside the jail, state can come up with policies for premature release. Now, this policy for prematurely releasing a convict must be transparent so that it does not violate the constitutional rights that are provided under Article 14 and Article 21. Now, Article 14, right to equality. Everyone should be treated equally. And Article 21, right to life. Now, these two happens to be one of the most important facets of our fundamental rights. So, the policy for premature releasing convicts, life convicts, people who are in life sentence, those policies must be objective, must be made in a transparent manner. The policy relating to premature release of life convict must be transparent and objective in nature, or else it's going to violate the rights which are guaranteed under Article 14 and Article 21 of the Indian Constitution. Any of these life convicts who have suffered many years inside the jail, the Supreme Court said, they have no resources. People are poor, and that's why you see the poor people inside the jail and the rich and the famous moving here and there. So the Supreme Court is very conscious of this fact that people who are in jail suffering lifetime imprisonment, most of them are with no resources, no money. So if there is no proper policy relating to premature release of these convicts, it would amount to violation of Article 14 and Article 21 of the Indian Constitution. Have I made myself clear to each and every one of you? Okay, so this is Rashidul Jafar versus State of Uttar Pradesh. Okay, am I clear, everyone? Now, apart from this, what were the important observations of the court? The court observed that there is lack of literacy, education, social support to these people who are in jail for a number of years. So people who are inside the jail, they lack literacy, there is lack of education, there is no social support to them, and hence their right to access legal remedies is limited. So most of the people are not aware of the important policies of the Supreme Court. Like you have a legal aid society, legal aid committee, okay? National Legal Aid Services Authority, State Legal Services Authority, District Legal Services Authority. So there are important authorities that have been given the total right to look into or rather providing access to justice to the poor and the needy. These people are not aware of it. Other observations from the court was, once the state has formulated its policy defining the terms of premature release, due consideration in time of the policy must be given to every eligible convict. Now, in case there is a policy by the state insofar as releasing prematurely a life convict, everyone who is eligible for that should be given due consideration. Now, using those policies only for a group of people is not fair. If there is a policy, that has to be given equally amongst all. That is what we understand by right to equality. Or else there will be no equality on earth. Article 14 stands violated, or else. Other observation from the court was that the constitutional guarantee against arbitrary treatment and of the right to secure life and personal liberty must not be foreclosed by an unfair process. Now, if the policy is made applicable not to everyone who is generally eligible. It violates Article 14. It also would violate Article 21 of the Indian Constitution. It will also violate Article 21 of the Indian Constitution. And henceforth, it is absolutely necessary that these policies are made applicable to everyone. Okay. The court also held that the Prison Administration Legal Services Authority at the district level, state level, and officers of the police department must diligently ensure that people or those prisoners who are eligible for the policies or those policies of the state government relating to premature release must be given consideration to. And henceforth, the Supreme Court says that there is a requirement for a change, because there are policies whereby people who are suffering for in life imprisonment, they can take benefit of these policies, but these policies are not aware of. These people who are inside the jail, they are not aware of it, and henceforth the problem. So the Supreme Court says that this situation must change and the court has to step in. Okay. Any doubts? Any doubts that you guys have? Any doubts? Okay. Any doubts that you guys have? Please let me know. Please let me know if you guys have any doubts. Okay. Can we move ahead? Can we move ahead? Okay. So guys, let's move ahead with the next important judgment, that is State of Jharkhand versus Salauddin Khan. Now in this case relates to Protection of Children from Sexual Offences Act, that is POSCO. Now the POSCO Act is an act that deals with sexual offences against children. Now this case was a case in which a person had committed a heinous crime, rape, and he went to the court asking for a bail. Now, should a person who has committed some heinous offenses, now what do we mean by heinous offenses? Murder, rape, and these are generally heinous offenses. So a person who has committed such an act, can the court grant bail to such an individual? Now, doesn't that individual a threat to other people around? Let's understand this. Is a person who has committed rape, is he absolutely normal? No, he is not normal. Hence, he is a threat to the peace and tranquility of our society. Right? He is a threat to peace in the society. And hence, should bail be granted to him? Let's see the allegation. So, the allegation was that there was this man who had forcibly picked up two minor girls on their motorcycles and had gang raped them. So there is a case of gang rape against these individuals. Now, should these kind of people be given bail? That means till it is proved that he has committed a crime, he can stay free. Should bail be granted to him? The court held that the High Court has not adverted to the parameters of Section 439, which are required to be observed while granting or declining regular bail. Now, there are provisions relating to grant and denial of bail, which are given under the CRPC, Code of Criminal Procedure. Now, here is an individual who is involved in a heinous crime. He is involved in one of the most serious crimes under the Indian Penal Code. Now, should he be given these kind of bail? Now, The Supreme Court said that the offer of payment at and ad interim compensation to the victim. Now, just because the person who is accused of committing the gang rape has paid certain compensation to the victim doesn't mean that it is a ground for him to be released under bail. Now, bail is to be granted. That is the rule. Bail is the rule and jail is the exception to the rule. But insofar as such kind of heinous offenses are concerned, now, would you give bail to someone like Ajmal Kasab, who was involved in the 26/11 Mumbai blasts, Mumbai attack? Now, here is certain things that you must understand. Just because a person who has committed rape has given some compensation, has provided some compensation to the victim or his family, should it be a ground to release him for bail, under bail? I'm sure that you have your own conscience. The High Court committed an error somewhere insofar as the application of the law is concerned. Okay. So, am I clear to each and every one? Am I clear to all of you guys? Am I clear to each and every one? Any doubts? Please tell me. Any doubts? You are most welcome to ask me about your doubts. Okay. Please tell me, guys. Any doubts? Okay. So, we are right now dealing with the fact that should a person who has committed heinous crime be given bail? Yes, Radha Krishnan has a question. Should legal terms and legal maxim asked in CLAT? You might get a passage on any particular law, and in that passage you might get a particular legal maxim. Then yes, legal maxim is important for each and every one of you. They might not ask you the meaning of a particular legal maxim, but if you are not aware and that maxim is featured anywhere inside the passage, it will be difficult for you to answer or to understand the passage. Okay. Let's move ahead. Okay. The next important judgment: legality of order setting defendant ex parte. Can it be challenged in appeal? Now, this is a particular judgment which I personally believe is not the most important judgment amongst the five. Amongst the five, this is the least important judgment. The first two are very important. The first three judgments are very, very important. Now, this one is lower in the rank. You should know. Now, there is this provision called the Civil Procedure Code. Now, this Civil Procedure Code deals with the procedure of law that is required to be followed insofar as civil cases are concerned. Now, what happened in this case? The question was whether the defendant who says that against whom there is an allegation that he has committed a civil wrong. So, the defendant did not avail the remedy under a provision of CPC. Whether that, since he did not avail that provision, is it open to him to agitate it in appeal against the entire decree of a trial court? Now, please try to understand that in case a court does not have jurisdiction, you have to go to the court and say that this court does not have jurisdiction. Now, if you do not challenge the jurisdiction there, later on appeal, can you challenge it before the higher court when an order has come into being? So, in this particular case, suppose a plaintiff and a defendant is there. The plaintiff institutes a case in a particular court. The defendant thinks that the court does not have any jurisdiction. Now, he did not challenge the jurisdiction of the court when the court took cognizance of the matter. Now, can he do so on an appeal? That's a pure question. The Supreme Court in this case said that though the appellant would not be entitled to lead evidence in appeal for making out a sufficient case for his absence before the court, he can always argue on the basis of the records of the suit, and either of the suit summons were not served upon him, or that, even otherwise, the trial court was not justified in proceeding with the ex parte against him. So the Supreme Court said that just because an ex parte order is passed, just because an ex parte order has been passed by a court, this does not take away the right of that individual to argue his case on the basis of the records that were before the court. Or he can definitely argue that the summons were not given to him, or that the trial court was not right, was not correct, was not justified in giving a judgment against him ex parte without hearing him. Ex parte means without hearing one side, okay? Ex parte. Only one party is there. The other party did not come, so the judge will give an order ex parte. Priyanka, is that clear? Every one of you. Is that clear to each and every one of you? So guys, if you're liking this session, do press the like button. Please like the session. Do share this session with your friends and others also who are preparing for CLAT and other law entrance examination. Okay? Do subscribe and press the bell icon so that you do not miss these classes that we are conducting. Definitely press the like button, and the chat box is up there. I can see all your comments out there. Fantastic. Great to see that. Okay. Moving on. Apart from this, the Supreme Court held that under the provisions of the CRPC, when you are challenging a judgment of a court in a higher court, there must be, what are you challenging? That means you are challenging an order which you think has an error, has a defect, has some irregularity. So, in your appeal, when you are appealing against an order, suppose I have got a judgment against me from a trial court, I have to challenge it before the high court. Now, in the memorandum of appeal, you must categorically clarify and state with no uncertainty the error, the defect, or the irregularity in the judgment that you are challenging. The Supreme Court held that if you are challenging a judgment, you can definitely argue on the appeal against the decree, as well as other orders that have been passed at an interlocutory state. That means in the interim, okay? There are certain orders, not the final judgment. There are various orders that are passed. So you can challenge everything in the whole in the appeal. Is that clear to each and every one of you listening to me right now? Okay? Is that clear? All of you? Any doubts? Summons means, suppose I file a case against Mr. A. I go to the court and summons will be issued against him, against Mr. A. The court will ask him, Mr. A, come to the court. There is a case against you. Come over here and justify why we should not impose compensation on you. Is that clear, everyone? Okay, moving on to the next question. But before that, have you registered for the All India Mega Mock CLAT 2023? It's live between 23rd of September and 2nd of October. It will give you a real CLAT experience. Now, these mocks are created by the expert team at BYJU'S Exam Prep, and definitely this Mega Mock Test 2023, which is live between 23rd and 2nd of October, will give you an idea about your strength and your weaknesses. Where all should you study more? Which all things are on your grip? That's going to help you. Apart from this, you will get a real life experience, real CLAT experience, and you can also identify how should you answer a question. Should you start from maths? Should you start from English? Should you start from GK? Or should you start from legal reasoning? Those are the things that will give you. So you can identify your strength, weakness, and you can also identify the right CLAT strategy for you insofar as solving the question is concerned. Moving on to the next important judgment, and that is Rajiv Shukla versus Gold Rush Sales. Now, if you are going to buy a vehicle, if you go to a showroom, a car showroom, and you book a car, and if you get a defective car, the Supreme Court said that delivering used or a defective car when a person has booked for a new car would amount to unfair trade practice and dishonesty and unethical practice. So suppose you go to a car showroom and you say that, okay, I want to buy this vehicle, and you pay some money as booking charge. Now, once you have paid full the consideration, you will get the vehicle, unless and until you are taking for you are taking a loan. So you are booking a vehicle, a new car, you have paid the money, and in return the car company gives you a defective or a second hand product, a used car or a defective car. Now, did you buy a defective car? Now, when you go to a shop to buy a product, do you want to buy a defective product? No, I'm not. I'm sure that you don't want to get a defective product. You want to get the best product, the right product. Now, here was a case where there was a non-delivery of a new car, and the Supreme Court held that selling defective cars or selling used cars would amount to unfair trade practice. It would amount to dishonesty. It would amount to immorality. Okay? These are unethical practices that companies should stop doing, or else they would be booked under unfair trade practices. Am I clear? Every one of you, is that clear? Any doubt? Any doubt? Please tell me. Any doubts? Okay? Fantastic. Let's move on. Okay. Now, apart from this, the Supreme Court observed that only new cars was booked for the full consideration. Now, you buy a car for 10 lakh rupees, you pay 10 lakh rupees, and you get something that is defective. How is it possible? That categorically amounts to unfair trade practice. Now, just because now you are booking a new car and you get a defective car. Now, the National Commission, in exercising the revisional jurisdiction, the National Commission had no jurisdiction to interfere on the concurrent finding of the District Court and the State Forum. Now, the State Forum held that if you give a defective car, it is violative of your consumer right. The State Commission also held so. But the National Commission said, gave some other order. So the Supreme Court held that the National Commission should not interfere, should not have interfered with the concurrent finding that was recorded by the District Forum as well as the State Commission on the evidences that were placed before the Commission. So the crux of the matter is simply this, that if you are buying a car, you will get a car without any defect. That is your right. If you get a defective car, that amounts to what? Unfair trade practice. It amounts to unfair trade practice. So, guys, did you all understand this particular thing? Did you all understand what is unfair trade practice? All of you? Any doubt? Any doubt? Please let me know. Any doubts? Okay. Am I clear to each and every one of you? Okay, fantastic. That's great. Yes, sir. Yes, sir. Fantastic. So, guys, do like this session. Do comment. How did you like the session? If you have any doubts, do give me your doubts after the live class is over. Do share this session and do subscribe to this very beautiful channel meant for students like you preparing for CLAT and other law entrance examination. Guys, do follow us on Instagram, YouTube, Facebook. Join our Telegram channel. It is going to give you a lot of information. And do not just forget to download the BYJU'S Exam Prep app. Once you download the BYJU'S Exam Prep app, you get all that you require to ace CLAT and other law entrance examination. So guys, with this, we come to the end of this session. Thank you very, very much. Stay home, stay safe, stay healthy. Have a great evening ahead. Bye-bye. Take care. See you. Good night. Thank you.